Good morning, everyone. My name is Xochitl Leon, and we're going to get started with CBA's Legislative Committee. If we may start with the roll call.
Luz Molina Lopez.
Michael Savoy.
I'm Dan Jacobson.
Thank you so much. So why don't we move on to item number 1, approval of the minutes of the January 18 Legislative Committee meeting. Do I have a motion for approval?
I so moved.
Thank you. Do we have a second?
I second.
Thank you so much. Any questions? Public comments? All right, motion approved, motion. Can we take a vote?
Ms. Molina Lopez?
Yes.
Ms. Leon?
Yes.
Mr. Jacobson?
Yes.
And Mr. Savoy?
Abstain.
Motion approved. All right, moving on to item number 2, the California Board of Accountancy 2018 Legislative Tracking Chart. That's a written report. Any questions? Comments? All right, thank you. Moving on to item number 3. We have a number of legislations that we're going to review. So bear with us as we go through them, and we love to hear back your feedback, considerations for us to take a position or not. If I may turn it on to Ms. Nushin, our legislative analyst.
Thank you, Madam Chair, and good morning, members and public members. Before I begin my presentation, I'd like to draw your attention to the small red books that are in front of you. These are pocket directories that we get every year, and they come in handy throughout the year, so those are for you to keep. And as Madam Chair mentioned, the written report only, I just wanted to highlight that there's 2 bills that the CBA took a support position on. Assembly Bill 703 did not pass out of its House of Origin, and Senate Bill 27 was held in suspense in the Senate Appropriations Committee. Next is item 3A, Assembly Bill 2087. According to the author, and as stated in the fact sheet, which is an attachment 2, this bill is an effort to modernize California's government by requiring each state agency, including the legislature, to establish modernization goals by 2020. These goals shall include goals towards modernization of the agency's information technology or IT system, and for usage of technologies that will improve the efficiency of the agency. Currently, the CBA, in conjunction with DCA, has begun a business modernization project identifying IT solutions in the automation of its examination, licensing, and enforcement activities. DCA has prepared a business modernization report for the CBA, which includes many of the items required by Senate Bill 2087. This document serves as a companion to broadly assess progress and provide recommendations during the implementation of the business modernization project. Staff recommend a watch position on this bill, and I'd like to turn it over for any questions.
Any comments, questions in regards to this bill? As you saw, we're doing a lot of this right now. I think watch makes sense. I was going back and forth between watch or support, since we're doing a lot of this already. But I'd love to hear the committee members' feedback or thoughts on this, or a motion.
We would require a motion in order to watch the bill.
So do we
to accept staff's position on a watch.
Okay, excellent.
I second that.
We have a second. Thank you. Any comments? All right, can we do roll call? Oh, any comments from the public? Excellent.
Okay, Michael Savoy,
Yes.
Luz Molina Lopez,
Yes.
Xochitl Leon,
Yes.
and Dan Jacobson.
Yes.
Motion carries. Thank you so much. Moving on to the next item, item number 10B3B.
Thank you. Assembly Bill 2138, and just for brevity, I will just say AB for Assembly Bill moving forward.
Okay.
If that's okay with Madam Chair.
Yeah.
This bill would prohibit a board within the DCA from denying a license based solely on an applicant's conviction of a nonviolent crime. Currently, and in accordance with Business and Professions Code Section 480, which can be found in your attachment 2, A board within the DCA may deny a license on the grounds that an applicant has, among other things, been convicted of a crime, done any act involving dishonesty or deceit, and any act that would be grounds for suspension or revocation. Effective January 1st, 2015, AB 2396 prohibited a board from denying an application for licensure based solely upon a conviction under the following circumstances: any felony conviction, any misdemeanor conviction, and any conviction that has been dismissed by the court. The CBA took an opposed position on AB 2396, and that letter is in your attachment 3. In this letter, the CBA stated that AB 2396 would eliminate denial of a licensure as an enforcement tool for consumer protection. As drafted, AB 2138, which is the bill in front of you, would change the following in Business and Professions Code, Section 480. It would prohibit a DCA board from denying an applicant solely based on a nonviolent crime conviction, and it would delete the policy enacted by AB 2396 from 2015, as described previously. Since 2010, the CBA has denied 47 applications for licensure pursuant to Business and Professions Code Section 480. Only 9 were nonviolent crime, or only 9 were violent crimes. If this bill is signed into law, the CBA would no longer be allowed to solely rely on nonviolent convictions. Instead, the CBA would need to conduct its own investigation to establish evidence sufficient to determine that an applicant met other criteria for denial in Business and Professions Code Section 480. If the CBA is unable to establish sufficient grounds to deny an applicant convicted of nonviolent crimes, the CBA may be required to issue a license. At this month's DCA Legislative Roundtable, staff from the Bureau of Real Estate voiced concerns about this bill, and DCA staff indicated that the author's office requests input from DCA boards regarding how to improve the bill. Staff recommend the CBA adopt a watch position on this bill and direct staff to do the following: send a letter expressing CBA concerns or comments on this bill, and offer to meet with the author's staff, which we do as a regular business practice already. If enacted as currently drafted, the CBA may incur unknown and possibly significant expenses to determine whether applicants convicted of nonviolent crimes should be denied licensure. And I'd like to turn it over to Madam Chair.
Any questions, comments? I think this, I like the recommendation from the staff. I think it's something that we should watch. It feels a little far-reaching at this point, but I'd love to hear what the rest of the committee members have to say, or if we have a motion on the floor.
I do have a question. I am curious to understand why the suggestion is to watch as instead of oppose. The author's office has expressed a willingness to hear from the various boards who have concerns regarding the bill, and so the watch position would give us an opportunity to resolve those issues cooperatively with the author's office and staff. Thank you.
I had the same issue, and I just wanted to express the reason behind it is my goodness, one of the main things that we do to protect the public is to watch out for fraud and that type of crime, which is not, by definition, a nonviolent crime. And so would staff then come back to us if there's not a change to protect the public from that sort of thing?
Yes, absolutely. We would bring that information back. This would also, would give us an opportunity to work with Assemblymember Lowe, who is the chair of the Business and Professions Committee on the Assembly side, and so this would line nicely to establish that rapport heading into next year's sunset review.
Do we have enough time to do something if they don't change it, to oppose it?
Erin's nodding yes in the back. Erin, can you come up and just address the calendar issues for me?
The timing.
If that's acceptable to Madam Chair.
Of course, of course.
Take over, Indy.
Good morning. So the question is about the legislative calendar. Well, so at this point, the next step would be the bill is going to move forward. We'll probably have a hearing sometime in April, by the end of April, in the Assembly Business and Professions Committee. But then by the time we come back in May, the bill is very likely to still be working through the legislative process, and so the CBA would still have an opportunity to take a different position at that time.
Excellent. So do we have a
And
motion?
I'll make a motion to recommend staff's position of a watch.
Excellent. Do we have a second?
I second.
We have a second. Excellent. Any questions, comments?
Will staff be at the hearing?
Tip-
Does it plan to be?
Yes.
Yeah,
Yep,
yes.
Staff will be at the meeting.
Any comments from the public? All right, can we call for a vote?
Dan Jacobson?
Yes.
Soshi Leon?
Yes.
Luz Molina Lopez?
Yes.
And Michael Savoy?
Yes.
Thank you. Motion carries. If we can move on to the next bill.
Thank you. AB 2483 would establish an Office of Supervision of Occupational Boards, or as I'll refer to this as office, within DCA to exercise active supervision over a covered board, including the CBA, to ensure compliance with specific policies regarding licensing and enforcement. Currently, a board within DCA acts as a semi-autonomous entity. The decisions of these entities with respect to setting standards, conducting examinations, passing candidates, and revoking licenses are not subject to review by the Director of DCA. AB 2483 would have a significant impact on the CBA by requiring the office to approve or reject any rule, policy, enforcement action, or other occupational licensure action. This bill also states that there shall be no right to appeal a decision of the office, and any appeal shall be to the Superior Court. According to the fact sheet, which is an attachment 2, this bill would ensure that occupational licensing laws are construed properly and applied to increase economic opportunities, promote competition, and encourage innovation in California. The fact sheet also cited the Little Hoover Commission's occupational licensing paper from a couple of years ago. At the March DC Legislative Roundtable, staff was informed that the Board of Professional Engineers, Land Surveyors, and Geologists took an opposed position on this bill due to a lack of funding mechanism. Last week, staff met with the author's office and was informed that Assemblyman Vopel's legislative director is eager to work with boards, and she was very appreciative of us reaching out to her. Staff recommend an opposed position on this bill as it would fundamentally change the relationship between the CBA and DCA and in essence remove the CBA's semi-autonomous status. I'd like to turn it back to Madam Chair.
Comments or questions? I mean, from my perspective, I see that the overall goal of the Little Hoover Commission makes sense. We do want to provide an advanced economic opportunity, promote competition for everyone in all professions, but this particular bill seems to contradict our role to protect consumers' protections here in California. So I would love to hear if there's any other thoughts or considerations or a motion on the floor.
I move to adopt the staff's recommendation.
Do we have a second?
I second.
Thank you. Any comments from or questions from the rest of the committee members or the public? All right, let's call for a roll.
Michael Savoy?
Yes.
Oh, I'm sorry.
Do we have a comment?
Joanne Hinkle. I hate to see another layer of government, but I do believe it's needed.
Okay, thank you. All right, we can call for a vote.
Okay, Michael Savoy?
Yes.
Luz Molina Lopez?
Yes.
Soshi Leon?
Yes,
And Dan Jacobson?
Yes.
motion carries. Thank you very much. Moving on to the next one.
Yes. AB 2958 would amend the provisions of the Bagley-Keene Open Meeting Act, or Open Meeting Act, with respect to teleconference locations. Currently, all CBA meetings follow the Open Meeting Act, which declares that meetings of public bodies and the writings of public officials and agencies shall be open to public scrutiny. AB 2958 would amend the act to include that all meetings held by state body by teleconference shall do the following: list a state body member or members participating via teleconference in the meeting minutes, designate a primary physical meeting location with at least one member attending at that location, include in the agenda the teleconference phone number and website, if applicable, to indicate how the public can access the meeting remotely, and on and after January 1st of 2019, prior to holding a meeting by teleconference, a state body shall adopt teleconference regulations. Currently, the CBA lists the teleconference location on all meeting agendas. The meeting minutes indicate whether a member was present, but does not specify whether they participated via teleconference. The CBA does not have teleconference regulations, and adopting new ones would take approximately 18 months or more. During this time period, the CBA would be prohibited from holding a meeting via teleconference. According to the fact sheet, which is in your attachment 2, AB 2958 would modernize the teleconference section of the Open Meeting Act and encourage more participation and engagement in public service. Staff recommend a watch position on this bill, but the CBA may wish to consider sending a letter to the author if it has any concerns with the legislation. And I'd like to turn it back to Madam Chair.
Any thoughts, comments, considerations?
I have a question. How often does a teleconference meeting like this happen
Not very often.
within this committee?
Rarely, but it's nice to have the flexibility.
It seems very nuanced from my perspective. The main concern is not having that flexibility for 18 months. But the good thing is that should we proceed with this, the overall impact to our board and our staff is minimal. So do we have a motion on the floor?
I move to adopt the staff's recommendation of watch.
Do we have a second?
Second.
Any comments?
Can I just ask an additional question?
Yep.
Can you provide me a little bit of granularity for why it would take 18 months to adopt?
That would actually, the regulatory process for us to implement something takes that long to go through the various review stages.
Okay. So it's not specific to the actions here, it's just in general, it takes that long to make a change. Got it, thank you.
Any comments from the public? All right, can we do roll call, please?
Dan Jacobson,
Yes.
Soshi Leon,
Yes.
Luz Molina Lopez,
Yes.
and Michael Savoy.
Yes.
Thank you, motion carries. Moving on to the next item.
SB 921 would add a section to the government code to require any state agency that maintains and operates its own website to post the number of employees, total authorized budget, and the sources of its funding for the current and 5 preceding fiscal years immediately below the heading. Currently, the CBA homepage displays its mission and vision statement, announcements, links to information regarding its licensing and enforcement programs, and upcoming events such as board meetings. The information specified in SB 921 is already publicly available, and although not posted in a specific location as the bill requires, it's on our website. Additionally, the information that's specified in the bill is currently available in various publications such as our annual report, the strategic plan and update, and these are also posted on the website and readily available if there's a request. Staff recommend a watch position on this bill.
Move to adopt.
I second that.
Any comments?
I think that the Controller's Office also has this information on its website.
Yeah, no, for our board, I think we're doing an excellent job.
Excuse me.
Yep.
I think this, though, would allow to be able to find that information much quicker, right?
Correct.
I mean, it would facilitate.
Standardization.
Right, it would facilitate the public to get to the information quicker, so, versus data mining.
Correct, but I think, it's all about web layout here, but what's the most critical information that someone who wants to get licensed should see right away? Just eating into the real estate right away. When we have, if they scroll down a little further, or if they click, they can see our annual report and get all this information. So, it's just trade-offs. But the information is publicly available.
And the watch position seems appropriate with all that.
I agree.
Okay. All right, any other comments or comments from the public? All right, can we take a roll?
Luz Molina Lopez,
Yes.
Michael Savoy.
Yes.
Dan Jacobson,
Yes.
and Soshi Leon.
Yes. Motion carries. Thank you so much. Moving on to the next item.
Okay, we're almost there. SB 984 would add a section to the government code to require that composition of state boards and commissions be at a minimum 50% women. Current government code section 11141, which can be found in attachment 2, states that every appointing authority should nominate a variety of persons of different backgrounds, abilities, interests, and opinions. Furthermore, the law states that it is not the intent of the legislature that specific formulas or ratios be utilized in complying with the government code. As written, SB 984 appears to be in conflict with Government Code 11141. Madam Chair, at your request, staff reviewed the board composition of several boards and found out that the pharmacy board is comprised of 4 women out of 12. That's a third. Our architects board has 4 women out of 10 members. Psychology board has 4 women out of 9 members, and the board of behavioral sciences and the optometry board have 8 women out of 11 to 13 members. In the last 7 years, the CBA has been comprised of at least 50% total appointees ranging from 12 to 15 members. SB 984 would not impact the CBA's current composition. Currently, we have 9 women on the board out of 15 appointees. Staff did not have a recommendation, and I'd like to turn it back to Madam Chair.
Awesome. So this particular proposal really piqued my interest, and that's why I asked, like, how do we compare to other boards, right? This particular board is amazing, it's super balanced, but this is this board, right? And this bill would impact all boards. When you look at it from the overall U.S. industry perspective, and even within state government, there's a huge opportunity for women. So for my opinion is, let's watch this. I don't know from a timing perspective where it is, but I think it can drive and set precedents for other entities. Comments from the rest of the board members?
I have a comment. I think I read along some of this literature that 22% of, in general, of other boards or of boards statewide, maybe, 22% are, women are in those positions. And so, yes, I do feel that equality is necessary, and I would approve this, would support this.
Any other comments before put a motion on the floor?
So, I run an organization, and although I have no specific statistical requirements to have women on our board or have any one particular group on our board, I have tried very hard to make it a balanced board, and for whatever reason, I've had a heck of a time getting women on our board, and I just don't want to handicap the appointing authorities with if they can't get someone, or if they and I think it goes down to the body politic electing enlightened appointing authorities who are going to appoint women to the board. So I agree with the watch position.
Yeah. And the other thing that we need to learn more about this is where the potential unintended consequences, right? Which we don't have a lot of detail at this stage, but it's something that I like to see. Okay, what are the pros and cons of doing this? And another question that surfaced for me is attendance, right? What does that mean in terms of operationally being able to manage a meeting? Do we need to have gender balance there as well? So I move to watch Bill SB 984. Do I have a second?
Yes, I second that.
Second. Excellent. Any other comments, questions?
I just have a quick comment to reference to Mr. Jacobson. It bugs me a lot that we would need to establish something such as this where we have to say by law 50% has to be women. I look forward to a time where it doesn't matter, you know, if it's a male or a female who's on a board. However, at this point in time, I feel that women do need to be empowered and encouraged. If they're not at the table currently, then what can we do to help them get to the table? And then it doesn't matter, you know. At one point it won't matter. Right now, I think it doesn't.
My sentiment is completely with you. It's just that from my experience, I think it could end up handicapping the appointing of authorities, and maybe there's a different answer that's much more fundamental than an absolute requirement. And I don't know, however, you and I are on the same page when it comes to how we feel, how we not feel how we think about this.
Any other comments or comments from the public? All right. Can we take a vote?
Soshi Leon,
Yes.
Luz Molina Lopez,
Yes.
Michael Savoy.
Yes.
And Dan Jacobson.
Yes.
Thank you. Motion carries. Moving on to the next item. SB 993.
Yes. This bill would impose an unspecified sales tax on the purchase of services. SB 993 would exempt healthcare services, education services, childcare, interest and insurance payments subject to the gross premiums tax, and a business with gross receipt of less than $100,000 in the previous 4 quarters. SB 993 does not have an impact on the CBA's mission of consumer protection. However, the bill would broaden the tax base by imposing a sales tax on services, including those provided by CPAs. In 2015, a similar bill was introduced by the author, SB 8. According to the author's office then, SB 8 sought to, quote, repair California's failed tax system to keep up with an economy that has evolved over the years from an agriculture and manufacturing-based economy to service-based economy. The CBA discussed the potential impact of this bill at that March meeting, and the LC minutes there's an excerpt in your attachments, in attachment 2. The CBA took a watch position on SB 8. This bill failed passage. Staff do not have a recommendation currently on SB 993, and it does not appear that it's related to the regulatory profession. So I'd like to turn it over to Madam Chair for any questions.
I think the key thing is, which you said, it's not, it doesn't impact CBA's mission of consumer protection, so.
Any other comments, thoughts, or considerations?
You know, it does greatly affect the accounting and law profession to a large extent in terms of maintaining clients. If you have a client that pays you $100,000, he's going to say, that's all I'm paying you. And so you eat the sales tax. So, I mean, I hope this fails the way the first one did, but this is not, while it's not affecting consumer protection, it is affecting our industry.
And I think, if I may, Madam Chairwoman, I think that in affecting our industry, it affects our licensees, and in that sense, does affect the public by putting an added burden on our licensees. I don't have a position as to whether to as to what to do with this, but I agree with Michael on where it should go.
Duly noted. Any other comments, or do we have a motion? At this point, the recommendation from the staff, there is none.
Sorry, I have a question. So I see that we don't have a recommendation from the staff. If we don't move to watch, then does this just
We would have to have a
fall?
motion to watch it.
Right. But if we don't adopt that motion,
Then,
it just falls off.
unless we have changes, but I'll
May
let
I?
our experts speak.
May I, Madam Chair? If the board doesn't take a watch, staff would monitor internally as we do. There's a last item on your agenda. We monitor bills, and if they progress into something that would relate to the CBA, we would bring it back in a full bill analysis at a later meeting.
So do we have a motion, or do we want to just?
I do move to watch, because I think that this would be such a burden on our licensees that it would affect the public, and so I move to that we have a watch position.
Okay,
I second.
excellent. Any more comments or comments from the public? All right, let's do a roll call.
Michael Savoy,
No.
Luz Molina Lopez,
Yes.
Soshi Leon,
Yes.
and Dan Jacobson.
Yes.
A little bit more work, but motion carries. All right, let's move on to the next item, SB 1121.
Yes. This bill would amend the Information Practice Act, or IPA, to revise the definition of business to include an entity that owns, licenses, collects, maintains, or possesses records. According to DC Legal Counsel, this bill does not apply to the CBA as a business. However, SB 1121 would impact CBA licensees such as sole proprietors, partnerships, etc. According to the author's office, this bill will modernize the IPA and is sponsored by the Consumer Attorneys of California. Staff recommend a watch position on this bill, and I'd like to turn it over to Madam Chair.
Excellent. Any questions, comments on this particular bill?
Move to adopt the watch position.
Do we have a second?
I second.
Do we have any comments?
I've studied the IPA extensively as part of my practice of law, and I'm not sure that I don't think it's needed. Anyways, I'm going to go with the watch position.
All right, do we have any comments from the public? All right, can we take a roll call?
All right. Dan Jacobson,
Yes.
Soshi Leon.
Yes.
Luz Molina Lopez.
Yes.
And Michael Savoy.
Yes.
Motion carries. Thank you so much. Moving on to the next bill, SB 1159.
Okay. At its January 2018 meeting, CBA, at the request of Senate Business Professions and Economic Development Committee, or as I will refer to Senate BNP, CBA staff prepared and presented a proposal which can be found in your attachment 2. This proposal would exempt CPAs with an inactive license who are current members of the legislature or Congress from the requirement to place the term inactive after their CPA designation. Senate BNP committee staff expressed a willingness to work with the CBA to pursue a legislative solution to the issue via an omnibus bill. The CBA approved the proposal at the January meeting. In February 2018, Senate BNP staff informed the CBA staff that at that time, it would not include the proposal in an omnibus bill due to potential opposition. Immediately thereafter, Senator Morlock's staff contacted CBA staff and advised that their office was introducing this bill, SB 1159, as a spot bill to be used as a vehicle for the CBA inactive designation proposal approved in January. Staff have been in contact with Senator Morlock's office to inform them that this bill is being considered during our meeting today. Senate Bill 1159 was amended earlier this week. The new version of the bill, which was a hand carry, includes the inactive designation proposal approved by the CBA in January. This bill is scheduled to be heard in the Senate BNP committee on April 2nd, and staff do not have a recommendation at this time. And I'd like to turn it over to Madam Chair.
So here we are. Thoughts, comments, we've gone through different iterations of this. It's back in our committee.
I've opposed this before, and I continue to oppose it. I think that if Senator Murlock and I don't know if Brad Sherman Congressman Sherman is behind this also, as it seemed to be that he was behind other issues related to this. I mean, they're both legislators and CPAs. If they want to be an active CPA, then they should be an active CPA. If they want to be an inactive CPA, then they should be an inactive CPA. And the designation is appropriate.
I have a question. It sounds like these authors really, really want this to happen. How many times have they sort of reintroduced or changed or
It's been at least
discontinued?
3 meetings that I can recall, at least, plus all the prep work.
So early on, there were a couple different proposals that were presented by the members, but it had more to do with the continuing education requirements, an exemption or some modification to that. The most recent language providing an exemption to using the designation was something that was discussed and proposed in consultation with BNP staff and board staff originally, before it was introduced by the senator.
Have these authors maybe sort of like exhausted their options? Is this pretty much the end of this?
We've compromised on our feelings on continuing education, and our staff came up with this proposal that we felt we can live with, and that's why it's now come to a spot bill. We felt okay with this. I want to leave it at that.
let me just mention that I know that lawyers who are members of the legislature will often still practice, and I'm estimating that the same is true for accountants, and therefore, if a lawyer is practicing and is inactive, well, that's inappropriate. And if a CPA is still practicing and is inactive, that's extremely inappropriate, and there's no reason why CPA A, who is in the legislature, and CPA B, who is not in the legislature, should have different requirements as to disclosure of whether they're active or inactive.
I agree. Mr. Savoy, if I can just, if my memory serves me right, I think it was a very slim majority of the CBA that approved, or that supports this.
I don't remember the vote.
You're right. I think it's in one of the attachments. Yes.
Yes.
So do we want to have a motion to watch, approve,
What are our
oppose?
options?
So not do anything, number one. Or, where's my cheat sheet here? Pretty much from supporting all the way to opposing.
Watch, oppose, support, and then you can do oppose if amended, or, various iterations of we like it, we don't like it, with amendments, without amendments. I mean, you can almost make up any sort of combination of that.
I move that we watch.
Do we have a second?
I second.
Awesome. Comments? Comments from the public? All right, let's do a roll call.
Okay, Dan Jacobson,
Yes.
Soshi Leon,
Yes.
Luz Molina Lopez,
Yes.
and Michael Savoy.
Yes.
All right, motion carries. Moving on to the next item. I think it's SB 1371.
Yes. This bill would add a section to Business and Professions Code to provide a list of occupational licenses and requires this list to be maintained by an unspecified entity. As written, SB 1371 lists the categories of licensure of the CBA for the CBA, including accountant and accounting firm. If the bill's intent is to provide a complete list of all licensees, it may be valuable to convey that information to the author and include the following for the CBA: certified public accountant, accountancy partnership, accountancy corporation, out-of-state firm registration, and fictitious name permit. These are minor changes, but will keep the bill's language consistent with the CBA's terminology. Additionally, the CBA oversees out-of-state licensees participating in California under the no notice, no fee mobility program. Although this may not be defined as a quote-unquote license, the CBA has regulatory oversight over these out-of-state licensees. Staff recommend a watch position on this bill, and I'd like to turn it over to Madam Chair.
Excellent. Any comments or motion?
I move to adopt the recommendation.
I second.
I second.
Any comments from the public? Any comments? All right, let's take a roll call.
Okay, Michael Savoy,
Yes.
Luz Molina Lopez,
Yes.
Soshi Leon,
Yes.
and Dan Jacobson.
Yes.
Thank you. Motion carries. Moving on to SB 1492.
Almost there, yeah. SB 1492 contains the two legislative proposals requested by the CBA to be included in the Senate BMP Omnibus Bill. At its November 2017 meeting, the CBA approved three proposals to amend Business and Professions Code Section 5095, 5100, and 5130. SB 1492 includes the proposals for Business and Professions Code Section 5095 and 5130. According to Senate BMP staff, the proposal for 5100, BPC 5100 will be amended into SB 1492 at a later time. This bill is scheduled for a Senate BMP committee hearing on April 23rd. Staff recommend a support position on the provisions of SB 1492 relating to the CBA. And this actually concludes my presentation. Thank you.
Excellent. Thank you. Any questions or comments?
Do we have a motion?
Move to adopt staff's recommendation of a support.
Excellent. Do we have a second? I second it. Any comments? Any comments from the public? Can we do roll call?
Okay, Dan Jacobson,
Yes.
Soshi Leon.
Yes.
Luz Molina Lopez,
Yes.
and Michael Savoy.
Yes.
Thank you. Motion carries. Moving on to the next item. Item L, other bills being monitored by the California Board of Accountancy. This is actually a written report. Any questions? Awesome. Moving on to the next item. Item number 4, legislative items for future meeting. Any topics or agenda items we want to bring back or start discussing in future meetings?
Yes. My review of laws that, or statutes that passed last year, it included the passage of Bill SB 547, codifications to Business and Professions Code sections 5063.3 and 5069.9. And my notes say that certain accountancy regulations expire on January 1, 2019. This law, which did pass, allows the Board of Accountancy to extend or remove that date. Have we looked into that?
Is that with regards to the mobility program, I believe?
I think it is.
Yeah, I think it established a Section 100 authority, so we can bring those we actually have those on our planned meeting topics for July,
Okay,
and which
Thank
will
you.
provide us enough time to get that changed if we need to.
thank you, that's what.
Awesome, and I skipped a critical piece, which is public comments. The California Board of Accountancy welcomes public comments during this section of the agenda. However, board members are prohibited by law from engaging in dialogue or taking a vote on any matter brought up during public comment. If you would like the CBA to discuss a general topic, you can ask the board to consider placing the issue in a future meeting agenda, provided it's not related to a specific case involving one of its licensees. If you have a pending application, investigation, or disciplinary charges, the CBA is prohibited by law from discussing any details or receiving evidence or information during the public comment portion of the meeting. In order to allow the CBA sufficient time to conduct its scheduled business, public comment will be limited to 5 minutes per speaker. Please make your comments focused and relevant to the duties of the CBA. And we have a comment.
I'm submitting, Joanne Hinkle, I'm submitting 8 petitions, administrative regulation petitions per California Government Code 11340.6 to make changes to the California Board of Accountancy to protect consumers and the disabled. My first petition, reason, it's impossible, and I have all the stats in here, for consumers to figure out what exact laws are enforceable with CBA's vague disclosure of laws on the CBA website. When I first called the CBA, because I've dealt with labor law, asked for a copy of the laws governing CPAs, I was given replies such as, just turn in your complaint and we will let you know if there's a violation. Every law you find on the internet that applies to CPAs, we enforce. These responses are degrading and insulting to consumers. Here are CBA's rules of professional conduct for compliance with standards, 29 words. In contrast, the rules of professional conduct disclosed to Oregon consumers are 14 pages long and presented on clear, easy-to-use website pages, and I have the link. The Board of Accountancy in other states, such as Oregon, are transparent to consumers and disclose CPA laws. In addition, other California boards are transparent and disclose their laws. The California Board of Pharmacy, Dental Board, Nursing, Medical Board, State Board of Optometry, Barbery, Cosmetology. CBA's website non-disclosure of laws and rules is damaging to the financial rights of California consumers and to the disabled. Second law. Petition to repeal a CBA law that is not followed by CBA inspectors and for which penalty is not enforced. CBA puts the rule on the book, maybe as a false promise to consumers and to look good to California state lawmakers, but the California CPAs know the law can be ignored, and the CBA earns a reputation as a kitty cat with toothless rules. Upon assignment of my 2 complaints, the CBA inspector, I'm sending a letter to the CPA asking for the letter of engagement, documents, and some questions. After I talked, no, I did not receive documents or letter of engagement. I called the CPA, he talked, he confused me even more. CPA said he had an appointment, he couldn't talk to me anymore. I was expecting the CPA to call back, but he never did. I will write a second letter and ask additional questions. When I called later, no, I received nothing, but that's not important, said the CBA inspector. I asked okay, I'll skip that part. The CBA inspector says, I know how 1031 exchange is done. Looking at these pages, I can't even see how 1 was done, let alone 2. And and I give evidence how you can tell that this is true. So my second request is for you to repeal a law that is not followed and just on your website to possibly bring comfort to people. Here's the third petition. The complaint process is unfair to consumers. All documents and emails received from the CBA during my 2.5-year complaint process are available upon request. No acknowledgement was received when I filed the 2 complaints on 2 CPAs. I received a letter that the complaint was assigned to 1 CPA inspector, but then I got a call that another inspector was assigned, and I never received a letter correcting that the first inspector was signed. No, let's see. I submitted evidence for the CPA's activities in May 2015. When I spoke to the inspector when it was assigned, he wanted the evidence again. And then I received several emails that he could not find the evidence. Could I submit it again? I submitted evidence 3 times. May 2015, when the inspector was assigned, and then when the inspector lost what I submitted. And I have emails from the inspector asking for that. The shocking experience of the welcome call from the CBA inspector. Hello, I do not have time for this case. I have 37 other cases on my desk. CBA prefers you take this case to court.
You have 30 seconds.
Well, taking a case to court with a disabled person is like asking the blind to see and the deaf to hear and the lame to walk. And also, if the blind wants to possibly go to court, the CPA's lawyer will make sure that there are threatening, if you go to court, I'm going to ask that the guardian be placed over you and you lose your rights.
Time's up.
Okay.
Thank you so much for your comments.
So this is the first 3.
All right, so with that, a meeting adjourns, committee meeting adjourns. Thank you so much.
Thank you.